Well, that was weird. That was really weird. So I had it playing Sweet Brown, and then when I go live, it did that little thingy, the countdown timer. I didn't like that at all. Anyway, how are you beautiful tubers doing tonight? Long time no see for all y'all. We are out here having a good time, great time, if you would. I don't know where I am yet. Um, that stream is over. This stream is on. And are we doing this right? I think so. All right. Anyway, y'all, waiting on Yolie to get here. I sent her the link. She said it works. Did I send something different? I don't know. What do you say to somebody? All right. Well, we'll see if she shows up. If she doesn't, though, we still got the same stuff. We'll go over it. Act like nothing happened. Y'all, how are you doing? It's been a hectic day, hasn't it? Man, it's just been it's weird. It's weird how things are lately. Um, oh, that's not good. Dude, hold on. What's happening here? I'm just reading the chat. Sorry, y'all. Shane says he's happy. So, starting, you may find me, says Shane. Yeah, that's how we always do it. Oh my gosh, let me tell you what, it was funny. So White Rabbit, like we came on and it was like, yes, yeah, it was like this. It was like side by side. And so it was like super closed in, like, it was like all you saw were like from here over. And she's like, yeah, I don't like this. What's going on? And her camera was like, it's a weird thing. She uses her laptop camera, and which is great because the stream only does 1080p. So it doesn't really like I can like the phone will do 4K, but who cares? You only streaming. I mean, you can upgrade maybe something like that. It's ridiculous. You don't need to see 4K. I mean, most people are watching on their phone anyway. So anyway, it was fun getting things situated with her, seeing how she liked it and everything. It was uh oh yeah, and I noticed Bad Duck, you didn't say anything about her having her camera mirrored. Yeah. So I noticed. I noticed. Anyway, do what? What's this? I use Discord with main chat where team experts doesn't say that. I don't know what you're talking about. Oh, well, you're talking to Shane, so I don't have any idea what you're talking about. Holy cow! Hey, Daniel Berry Sports Highlights. How you doing, guys? It is weird, so you don't have the chat over here, but you don't have the avatars. I gotta figure out if that can be changed. Also, there's another thing. Cloudbot. What's that? Widgets. Oh, hang on. Can I do that? I wonder if I can do that. No. Oh, that's what I need to do. I could have done that. But what if I did? No. There's a way to do something, I thought. Oh well. I'll figure it out. Bad Duck, how you doing, bud? Man, I'm worried about you. So bad, Doug. I took a screenshot of your joke. I don't know how to do images over here. Does that make sense? Undo a new background. Oh, wait a second. What if I did this? Oh, bad duck. You're gonna be the first if this works. Guess what, bud? You're gonna be the first one. Oh my gosh, look at that. Oh my gosh, I figured it out. How do you catch a unique rabbit? You sneak up on it. Chili, if hey, Shane, if I don't know if I have Shelly's contact stuff in Discord. If you can get a message to her, then I'll send her a direct link to the chat if she wants to get into it. That is so cool. So Bad Doug, you're the first one, bud. I can delete it too. Oh my gosh. And look at this. We're gonna have somebody come on. Yay! Well, that's way too big. What's happening here?
Can you hear me?
I can hear you. Hang on a second though. We got
Can't hear.
you can't hear? That's not good. There we go. That's better looking. You can't hear? Hello. I was talking a second ago. I think the chat can hear me. Can chat hear me? We can hear you.
Can't hear you.
We hear you. You are good.
I can't hear you.
So check your input. Look at where is it? Look where there it says mute. See down there on the bottom? It has like a little the microphone on the bottom at the left. There's a little arrow. And make sure that your input or your output.
You can.
I mean,
They can
your
hear
output
both
is
of us, but we
your.
can't hear each other. Let me see.
Oh,
my
wait a second.
microphone.
Well, I'm talking to her. She can't hear me. Gosh, I'm so bad. Hang on. I'm open.
Hmm.
Does that make sense? Can you see that? I don't know how to control her stuff. I can kick her. No, I can mute her. I'm not doing that.
Hold on.
And turn her volume up. Do you hear me? Oh, she's gone now. Hey, Christine Fortunato, how you doing? Yeah. So like that happened to White Rabbit too. She came in. I can't figure that out. You like how I went to a new platform and I'm forcing everybody to accept it. Wait till Friday, it's gonna be a blast. Maybe I just fired up on StreamYards.
Can you hear me now?
I hear you. I've heard you the whole time.
I can't hear you.
You hear me? You can? Okay. Can you hear me?
Let me see if I do this. Hold on.
Oh my gosh. Hey, Squid, what's happening? Can you hear me? Hello? Hello? Oh, there you go. Hello? Hello? Hello?
I can't hear you. I don't know what to do.
Hang on. I'm gonna send you a message. Hang on. Okay. I use Discord. I mean, why don't I have control over this? Participants. Troubleshooting. Hey, Belvy, how you doing?
I know what's wrong. I know what's wrong. Hold
awesome.
on.
Okay. Oh, I bet she's hooked into her phone. What you guys want to bet on it? Okay, hang on. So where did Belvy? Hey, Nolanator's here. I love the name Nolanator. Jen, Thunder, and Lightning.
There we go.
Oh, you got it?
I got it.
Awesome.
Figured it
What
out.
happened? What was it?
Well, I guess this isn't StreamYard, so it's set to my it's set a different, I don't know what it was set to something else. I don't know.
Squid, it's Streamlabs, Studio Talk, and so it has a lot of really neat features. Trying to get used to it, so I'm forcing it on everybody. And but the good thing is it's like $30 a month less than what StreamYard is, and it's the video looks a lot better. Somebody was saying the sound sounded better, so we'll see how it works. But everybody has a struggle getting on, and I've been having a struggle.
And I guess I can't chat, right?
Yeah, you can chat. Oh no, it's not. Is it say you can't chat?
It says sending messages is only supported for hosts.
Okay, so you gotta do that through YouTube. Yeah, see, like I have YouTube. I have my chat popped out and on the left side of my screen.
Okay.
Harriet Williams has been a member for 11 months. Oh my gosh, we need to have like next month be a celebration. There's a lot of 11 monthers here. And Belle V, have you ever met Belle V, Yolie?
No.
Oh man, she's a hoot. Oh my gosh, I love that girl. Oh my gosh.
Belle V. No.
Belle V. Oh my gosh, she is awesome. I got it's so many great people. I mean, just wonderful people around here, and Belle's one of them. Oh, I love her. So, and hold on here. So Nolanator's asking, have you read every book behind you?
Most of them, yeah.
I have about 7 comic books I haven't gotten to, and then like regular books, yeah, I just don't read.
Yeah, I have. There are a lot of true crime books.
Yeah, you were saying that last night that you're into all that stuff. So anyway, oh look, Deborah Kennedy, who's the pretty Yolie lady? There you go. Well, tell us a little bit about yourself, Yolie.
Oh, okay. So I'm a civil attorney. I do medical malpractice cases. So I've always liked criminal law. So I'm a true crime follower. That's kind of my hobby. So when I had some downtime when COVID hit and the courts are trying to get back together and they're still not back together, I just started on YouTube and I started looking around, for true crime shows. And then the Idaho 4 case hit with the 4 students in Idaho, and I was following that case. And then I started going on shows on different people's lives. And then I started my own channel, and that's where I am. I have my own channel. And like today, I was on a live with Andrew Myers. He called me out of the blue and wanted to go over the Karen Reed thing. And I happened to have some time. So we did a live. So I haven't done a live on my show though. But yeah, I'm a civil attorney, not criminal.
But I found I, Broken Baker found you is how you got in my world. And
Yes.
hang on a second here. There's a couple things I need to answer. One, I forget who just asked about your a link to your page. So I put a link. Oh, good.
Hmm.
Hang on a second. Maybe two things. So I'm gonna pin. So Yoli's link is at the top of the chat now, and also she's in the description of the video. Okay, so go over there and support her. She is absolutely awesome. So Yolie is. Oh, and by the way, also Christine Fortunato. Yes, I saw you on Belvise, and you look beautiful. It was absolutely great. Of course, all of you girls over there look beautiful.
Mm.
I'm a
I
sucker.
have some Squid Pro Quo says most of the books on her shelf are anatomy and physiology, and I have some anatomy and physiology books too, textbooks.
I've got the Kama Sutra, but it's on
As
PDF.
a matter of fact, I have a genetics book. I took genetics. See,
Yeah, that's.
I have all kinds of books.
I've got a.
Let's see, your comic book.
Yeah, yeah. I was gonna say, what's my last conference? No, I picked them up. I have Batman and the Ninja Turtles. You read that? Got the first edition of it. Pretty special. So anyway, y'all. So Yolie, Broken Baker, he found her, which I don't remember. How did he find you? He was just scrolling.
He, I guess he was just scrolling and he found me and he wanted to do the 12 creators for Christmas or something.
Oh, you were one of them.
Yeah, I was one of them. And so he emailed me and he asked me to come on the show and I did. And so that's how I met this group. And then I started following Baker because he does trials in the morning. And I can at least listen, like I have something to listen to in the background, the trials. I
Mm-hmm.
can't really chat too much, but I can listen. And so that's good. I have something to listen to in the morning when I'm working. And so then I saw that he had a post. He had a post that said, "Come join me," and it was to the experts channel, and it was a
Mm-hmm.
Friday night, and I went over there. Oh my God, I laughed so hard. It was better
Oh,
than
crazy.
Saturday Night Live. I laughed so hard. I was laughing so hard that I had to email Baker, and I said, "Oh my God, this is the funniest show ever."
Oh.
I was like, "Thank you for introducing me." Oh, there's Broken Baker.
Oh, is he here?
Yeah.
Oh, there
Oh
he
my
is. I'm
God,
so
I
sorry
laughed
I
so
did that.
hard.
Yeah, he should be sorry. He owes you now. He owes you.
Oh, I could not stop laughing. I mean, it was just one thing after another, and it was hilarious.
Oh man. Yeah, Broken Baker, he's an amazing guy. It's
Boy, this
and
camera makes me look so white.
boy, I tell you what, it's so funny. Okay, this is so funny the way you said that. I just had to go to the DMV, get a new ID thing,
The
and
what?
I had to get a new picture, my ID.
Oh,
I feel like moved and everything else, and the whole point's the picture. So like they get that ring light, right? I told the lady, I was like, I don't like this lighting at all. I said, look, I do I'm like a YouTube creator. I was like, lighting is everything. I hate ring lights. It's so I was like, I looked like a wet ghost. And I didn't know ghosts
I
could
feel
be
like
wet
right
until I
now,
was,
I feel
yeah,
like a wet
right.
ghost right now. But
Right? It's
I have a monitor up here that has the Caribbean on it right now, so it's green. Uh, I don't know how to turn it off, the monitor.
don't worry about it.
Well,
You're
maybe I
fine.
can just turn it off.
Oh
That's a little
wow.
better.
Yeah, isn't that amazing? So like they sell you on all this thing about lighting, right? And then when you get all the lighting and everything, you realize it's not really all that great. It's uh yeah, it's I don't know.
Well, this
But
is better. At least I don't look like a ghost.
what ghost? That was me. I was like, and she said, well, you can take another picture. And I was like, so that's my
No,
idea.
and then my black hair is just like, I don't know, feel like Elvira.
Well, that's okay. At least you don't look like I
Yeah.
do. It's horrible. I've been to the tanning bed again. I was like, I've never been this long without going to tan. I love the tanning bed, like especially in the wintertime. Like it's that light therapy and all that. It just gets to me, helps me because I hate long dark winters.
Oh, I hate it too.
Um, yeah, Melanator. I realized that kind of after I said that. I wasn't trying to go that way, but I did. I was like, why do I look wet in
Well,
this
like,
picture? I was maybe I think I wore a blue shirt. I don't know. My
I
and
have to
all
go
this
get
was
my
so I'd
real ID.
save $15.
Yeah, I have to get my real ID too. My real
Oh,
ID driver's license.
yeah, I turned that down, so
Oh,
I can't
really?
get leave the country. Yeah, they were like, you can't go into like federal buildings. I was like, bonus.
Mhm.
But anyway, no, I rather have a passport than like make them look for it. Besides that, it's like Broken Baker. He came to America. He had his ID, and they wouldn't serve him beer.
Hmm.
So what does it matter? So, see, look, you're messing
Yeah.
with the lights. You're like me. It messes with you. Oh, it's all the
Interesting.
little things. It's a million little things. It's death by a thousand paper cuts.
Yeah.
Um, Major Mom is interested in cold cases. White Rabbit watches that show, Cold Cases. Have you ever seen that, Yelling?
Yeah.
It's these two women. They go out and they find stuff from like 100 years ago, and it's like modern Cagney and Lacey or something. I don't know.
Yeah. I've watched it before.
Yeah. Anyway, so tonight, uh, last night, if y'all missed it, Yolie was kind enough to come on screen. Just we're having a shoot the crap string. A few things were going on, and then all of a sudden, I was talking about well, there is stuff, new stuff came in, dropped out with the Hales legal drama. Is that
Yeah.
I called it the Otter Creek Gate earlier
It's
because
kind of strange that, yeah. So I saw the documents you sent me.
okay, good, good. I didn't know if those went through or not.
It's weird. It's
Um,
just a weird case. I mean, I understand that it's a defamation case, but this counterclaim that I don't quite know.
yeah. So yeah, it's I've been removed from reality. You know how we were talking about last night, how you're like, you got to get away from all the business part, and
Yeah.
you get around real people and stuff every once in a while. I've been removed from that business part for long enough that I'm there's another thought is creeps in with me is my overlying thought with the whole issue, and that is what is the defense, what is their lawyer, what's the end game, what is the goal there? Because I don't think they got into this because, well, I mean, um they just came out of Massachusetts, said, hey, I'll represent you, to somebody who they didn't know, somebody you meet on the internet. And so immediately the first thing I think of is if you're on the internet, you're grifting somehow. You want something. There's something
Advertising.
else you're going for. Yeah, everybody thinks it's that big YouTube money. Anyway, yes, deeper too. To catch up, you need a too long didn't read for the too long didn't read part of the what the hell's. Yeah, it's double TLDRs square. Um, yeah, there you go. So that's what we're gonna go over that right now. We're gonna do our own. It's like Squid was reading it earlier, and I'm sure everybody else has been reading it. But our my goal, and we were talking last night, so I hope we're on the same page, is just to follow the what is on the paper. There's no outside interference, no drama, nothing like that. And then we'll just have a conversation using, our just being an us.
Yeah.
That makes sense.
So the only thing that I'm confused about is
Yeah.
whether or not there is a counterclaim. I believe we said there was only an answer, right?
Yeah, it's a if you're trying to say there's a counterclaim in the answer.
Okay.
Remember when we kept talking like
Yeah.
how do you separate the two? You can't throw out the counterclaim separately from the answer, can you? I mean,
No, I think it has. I'm pretty sure it has to be separate. The counter complaint or counterclaim.
let's put it. Here's the way I feel, and I'm probably not right, but if this weird legal acrobatic maneuvering that you'd have to do to make the answer and the complaint, or yeah,
Counterclaim.
all in the same thing, the counterclaim and the answer the same thing. That's so beyond what the magistrate, because the magistrate's underneath the actual federal
Right.
judge. And so, I mean, they see the lesser cases. And so they're not, this would be like case stuff like you study in like at some sort of advanced law class or something. It's so
Yeah.
minute. Nobody does this. I'm
No,
not
I
saying
meant.
what I'm. The reason why I
Yeah.
say this because I'm not saying it's wrong, but it doesn't seem like it's typical.
No, and I'm pretty sure it has to be two separate documents because you don't respond to an answer unless you're going to do a motion to strike or some other motion against the complaint. But if you have a cross complaint filed separately, cross claim, then the defendant or the plaintiff is on notice that there is a claim against them so that they can respond and file a counter answer to the counter complaint or some kind of motion to dismiss the counter complaint. But it seems like there's this fictional counterclaim that everybody's assuming is there, and now the plaintiffs have brought a summary judgment motion against the counterclaim saying there's no tribal issue of fact. There's no genuine issue of fact.
Well, I don't know. I haven't read it yet.
So I looked at it, I reread it.
I know. That's what I was like. Well, you read it, because that's me. Like I like having the raw aspect of it. So, all right, let's see. Let's see what let's see what the first one is here. Wait, hold on. Cancel that. Okay, so we don't need to do. I mean, let's just go ahead and bring it up, right? No, wait, window. Sorry. Is it that one? Yeah, it should be this one. So this is just the motion for. Yes, I got the stupid thing up here. There we go. It's out of my way. Motion for summary judgment on counterclaim. This is okay. So this is the plaintiff's attorney. That's what I want to make sure on this.
Right.
Motion for summary judgment on counterclaim filed by defendant Cook. And there's Cook and there's Preston. There's one of these for each of them. I'm assuming it's the same language, just for brevity. Let's just go with that.
Yeah, it says document 69, so I don't know what document 69 is, if it's the answer or what.
That's what it was yesterday we were reading.
Okay.
I think that was in 69.
Oh, the request. Okay.
Yeah.
For dismissal.
So, let's hear plaintiff counter defendant moves for summary judgment on defendant counter plaintiff counterclaims as there is no genuine dispute as to any material fact, and Mr. Hales is entitled to judgment as a matter of law. No facts of the case can be reasonably disputed. Yeah, they haven't disputed any facts, have they?
Well, you know, the defendant is going to get a chance to oppose this summary judgment motion.
Oh my gosh.
They have to oppose it, and if they don't oppose it, then possibly the summary judgment gets granted. But if there's no counterclaim, I don't know how the judge is going to handle that. If there really is no counterclaim, in other words, if the judge isn't going to recognize that the answer contains a counterclaim.
So, let's see if I can do this. I can't do that. Why can't I? I'm sorry. I'm trying to get used to the styles here still.
Oh
Because
my
what I
God, the
want to do
border
is,
matches my sweater. That's funny.
oh, look at you.
Huh.
So, can I stop this for a second? That messes everything up. Okay, so I don't like. Sorry, I was just messing around with the buttons. I don't like how it is. But what I want to say is it's almost as if they are trying to go. They're ahead of the judge, and it's like you're trying to point the direction they want the court to go into, and the judge
Well,
hasn't ruled on previous matters yet.
yeah, like
Previous
how many
orders.
previous matters there are, I'm wondering. Because I don't know. I don't know how many there
Yeah,
are, but the one document we were reading yesterday was a request for dismissal on the counterclaim, on the, what was it? Prospective counterclaim. I don't remember how it was titled, but it was titled conditional. It was on the conditional counterclaim, something like that.
yeah, it
So,
was.
it, yeah,
Hang on, was it yesterday? Was
conditional.
let's see here. It was. Let's see. Let's do this and go. That's not it. Hold on, sorry. That is this one. So yeah, yesterday was the
Uh-huh. A conditional request.
conditional request that if under 41A it gets dismissed, they want to concomitantly uh
Concomitantly. Can't
I
say it.
see you
Yeah.
messed me up. You know what, I said it 3 times today perfectly,
Concomitant.
and I realized what the problem is my tongue trips. I don't know how else to explain that. I can't get my tongue to make the
Concomitantly.
yeah, it's weird. Concomitantly.
There you go. You said it right. I think it
If
sounded
I
right.
if I relax, I can do it. Concom concomitantly, sorry. Concomitantly dismiss. Concomitantly meaning that it would be parallel or be of the same thing, right?
Yeah.
Like with it. So it's
Like
like, oh,
along,
we're
like
gonna dismiss it
concurrently. They could have used
yeah,
concurrently dismiss. Instead of
yes.
concomitantly, they could have used concurrently dismiss.
But they have to use the 75-cent words, not the
Yeah.
25 cent. So I don't know where I got it. That's a 75-cent word there. All right, let's see here. So
I
let me
guess
get back.
concurrently is a 50-cent word.
Yeah, it would be. Yeah, you're right. All right, where were we here? Oops, no, sorry. I think it's on. Shoot, which one did I just have up?
You had the other, this is the conditional request to,
Yeah, I'm trying to see. Okay, it's this one. Sorry. So it is. This one's. Share that one. Sorry. All right, that's it. No, that's not it.
see that's document 76.
What was I just on?
I didn't see the document number on the other one, the conditional request for
Oh,
dismissal.
it's 73. Sorry.
Yeah. So I don't know what document 69 is. So that would be what you need to see. But for the purposes of going over this, it's just a summary judgment motion on a potential counterclaim.
We can have zero. Do you want 69?
I don't know. I just want, yeah, it would be good to see.
All right, let's do 69. Okay, so this is 69. The answer to affirmative defense and
And
counterclaim.
Ah, well, I don't know if they can do that. There might be something in the federal rule in the district of where this case is that allows that. But normally it's two different documents.
Is that right? You do? So, I'm sorry. I'm a grammar person here, and it's like so it's like goes from summary of the case to the parties. And I just thought that was jurisdiction and venue.
Denied
They
your
number their paragraphs instead of those. Usually, you answer with the number. So, like 8 would be 8 to the claim, right?
yeah.
Like if,
To
if
the
like claim, you have all these numbers. Like 1, we claim this. 7, 8, we claim
causes of
this, and
action, yeah.
so when you answer, 8 would be the denial or whatever for number 8 on the claim.
Yes.
So that's why it's weird. It has jurisdiction and venue. It's like it's titling the sections. I don't know. I had to see the other one. So, and then factual allegations. Let's see.
Admit,
Blah, blah.
unable. What?
Sorry.
Admit. So they're going to the paragraph.
Yeah.
They're responding to requests for admissions. That's weird.
Oh my gosh. Hold on a second. Look, he just derailed this whole thing. Bad duck. The old defendant side are crazier than a coonhound with an empty Kong. That's my dog he's talking about there. We're gonna say for all intents and purposes, that's why rabbit wiggle. Yeah, but guess what? Wiggle. That's the only thing I have. Thank you, Bad Duck. Thank you, Bad Duck. It took forever to do this stuff because I do it in a jacked up way. But anyway, sorry.
Okay, so I'm not sure what's going on here. It looks like they're admitting they're answering requests for admissions in the answer.
Yeah. You have to go all the way back to the beginning. So it's either. That's what I'm saying. Like, okay, hang on. Let's try to do tonight. Let's just try to do tonight, okay. And then you and I can talk, and we may have to go back to the beginning. We may just start to talk. You know what? This may become the Yolie and expert hour. You know, and we just go from day one, and read stuff.
Yeah, you know, there may be something that allows them to do this, the counterclaim and the answer together, but I don't know. But then it sort of morphs into answering requests for admissions in this answer affirmative defenses and counterclaims. Did they get confused? Yeah. Okay.
It doesn't make sense. So, all right, we did this is right, isn't it? This is where we are, 76. Yep. Holy cow, man! It's well, no, that's not moving. Why do I have a different page? I'm on 69. Is that?
That's right.
No, yeah, but I'm not down here, so I can't scroll. I don't know what happened to my paper. There it is. Finally, I got it. There, now I got control. Okay, so the memorandums in support of summary judgment. Yeah, this is so weird, isn't it? On counterclaim filed by defendant Cook on document 69.
Okay. That kind of makes sense. Now, at least they're referring to the same document.
Richard Thornton here is saying that 69 is a filing for initial filings a year ago. The filing is out of order and should have been filed in 21 days of its posting, which was a year ago.
This is crazy. Okay.
Yeah. How do you...
Has the judge made any ruling on anything in this case?
Yeah. I don't remember what the last thing was.
Was it expert witnesses?
Yeah, well, so expert that was they asked for a continuation to get expert witnesses, but
Hmm.
they had run out of time. The defense had, and anyway, they're asking
No.
for continuance, and the judge said, "Was it you can?" I think it was what, like 2 weeks, maybe. It was when the judge tossed all the RICO stuff. That was the last thing the
Oh,
judge
that's the
did.
last. Yeah, that's right. No, I just said Doug Croxall or Croxall is saying. Did she say it makes sense? I just saying that it makes sense now that I know what document 69 is. That's the answer, and in it is the counterclaim. So they're referring to
Yeah.
it.
All right. So, where defendant or where, as here, counter defendant moves for summary judgment on issue for which it should not bear the burden of proof at trial, it is not necessary for the defendant to entirely negate the plaintiff's claim. Fitzpatrick v. Atlanta, the 11th Circuit. I like that they actually use 11th Circuit
Hmm.
stuff.
Yeah.
Um, let's see here. We find no express or implied requirement in Rule 56 that the moving party support its motion with affidavits or other similar materials negating the opponent's claim. Emphasis in original. Instead, the
Yeah.
movement
Yeah.
has what? Okay,
Yeah. I
has
was
the
just gonna
burden of
say. Well, I
yeah.
was just gonna say that normally when you have a summary judgment, you have an affidavit of somebody,
Mhm.
or you have like a deposition testimony of a person, where they state something and it's bad for their own case. But in this case, they said Rule 56, and let me just read that again. Rule 56 up. It says, we find no express or implied requirement in Rule 56 that the moving parties support its motion. Okay? And they apparently support it with case law. So, okay.
Very good. Instead, the movement has a burden of either negating an essential element of the non-moving party's case or showing that there is no evidence to prove a fact necessary to the non-moving party's case. McGee v. Sentinel Offenders, 11th Circuit. Once a summary judgment movement's initial burden is met, the burden shifts to the non-moving party to bring the court's attention to evidence demonstrating a genuine issue for trial. And this is another 11th Circuit case in 2014. Overcoming that burden requires more than speculation or a mere scintilla of evidence.
Scintilla. Scintilla.
Scintilla. I like scintilla.
Okay, scintilla.
See? Scintilla. Scintilla is that's like Italian, man. Like this, like the Tennessee stuff's like
I like
scintilla.
scintilla.
Scintilla. It's a scintilla.
Like a skin cell. Or a mere skin cell.
I mean, I guess, like, see, for it to be scintilla, it needs to have an E after that I, like science.
God, that's funny.
That's how it works in my brain.
I'm thinking of a skin cell. More than speculation or a mere skin cell of evidence. That would be the Kohlberger case, but never mind. Never mind.
Skin cell, right?
Never mind.
The moment must go beyond the pleadings to provide evidence and designate specific facts showing that there is a genuine issue for trial. The Silatex case, internal. I didn't say where that is. The non-movement. Do what?
I think it's
U.S.
above, yeah.
Yeah, sorry.
U.S. Supreme Court.
The non-movement will survive summary judgment in the instance if it can demonstrate that the record in fact contains supporting evidence sufficient to withstand a directed verdict motion. That would be Drummond, 11th Circuit. So, what's your thoughts? Like, explain that to a
layperson?
Yeah.
Okay, so first of all, they say that there's support, and I haven't looked at the case, but there's support where they don't have to use an affidavit or evidence from anything outside of what's legally pled, what's legally articulated in their papers for the counterclaim, assuming it's a counterclaim. Then now they're saying that the plaintiff or counter defendant is filing this motion for summary judgment saying that based on the written counterclaim alone, as a matter of law, it's insufficient to prove a claim against the counter plaintiff against the plaintiff counter defendant.
Oh my gosh, this is like
so they're just going by the papers. That's what they're doing. Is there the plaintiff counter defendant is saying, look, based on the papers for the counterclaim, and I'm pretty sure they cite paragraphs of the counterclaim, and they're basically saying, based on the papers for the counterclaim and based on what is written, it's not enough to show that there's a claim against the plaintiff counter defendant. So summary judgment should be granted
on the so-called counterclaim.
Yeah, and this is just on the papers, on what's written in the counterclaim.
And isn't that weird that it's because you have to, it's a razor thin, this is surgical precision trying to cut out that the claim, the counterclaim in with the answer.
Right.
Does that make sense? Like
Yeah.
I mean, I wouldn't even know how you begin to even think this way. It hurts my head. I mean, it really does. It's overwhelming.
Well, the counterclaim is probably it's in the answer somewhere, and I'm sure they're going to cite to the paragraphs to it. I think they do, because I looked at it. They cite 2 paragraphs of the counterclaim that is in the answer, and they say this is not enough. There's nothing alleged that would rise to a claim.
Bad Duck says the whole. Oh wait, no, I saw that one. That was a good one, Bad Duck. That was great. It's so good he gets another read. And Bad Duck says, always love a woman for her personality. They have like 10, so you can choose. Yeah. Bad Duck is like I don't know how to explain it. Well, yeah, he's a bad quack. And then where'd the other one go? I saw Bad Duck did another, and he gifted some memberships, but the gifted memberships don't pop up over here.
Yeah, this is really different than StreamYard.
There you go. Thank you, Bad Duck. Man, I'll eventually get used to this, right? Nope, I won't today.
Well, a lot of people use Streamlabs. I've noticed.
Yeah, they do the OBS thing though. Wiggle, 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 wiggle. There you go, Bad Duck. Oh, Bad Duck's actually, he's turned backwards on the far end. You gotta look for him though. Yeah, there's a lot that I really do like about this program. It's just that it's not what I'm used to using for the last several years.
You just have to get used to it. Yeah.
And I mean, you guys see how bad I am with pushing buttons on the other thing. I mean, come on. The fact that I can even turn this thing on is a major achievement. All right, so let's see here. Where was drumming? Okay, so the statement of material facts. The counterclaims filed by defendant, co-plaintiff Cook, and we're assuming Preston as well. The defendants hereinafter are entirely based upon plaintiff's YouTube content. In fact, the counterclaim mentions YouTube content as the basis for each of its 3 counts. Paragraph 1, litigation related to YouTube as a polymop. The
purposeful protraction of litigation and multiplication of proceedings.
It's a mouthful, isn't it?
We talked about that yesterday.
Yeah, I was calling it prolapse.
Yeah. Okay. But that's paragraph 1 of paragraph 1 of count 1. Oh no, paragraph 1
of the counterclaim filed by the defendant. See, I mean, look how confusing it is. The counterclaims filed by the defendant slash counter plaintiff.
Uh-huh.
So,
So the
mean, this is
defendant is a counter plaintiff as well as a defendant, and the plaintiff is a plaintiff as well as a counter defendant.
yeah.
So they're both plaintiffs and defendants.
At this point, yeah.
It's the easiest way to.
Is there a third thing that they can be added to it?
I don't know.
I mean, honestly, this is no. In paragraph 2, ongoing litigation generating fresh, compelling YouTube content. Paragraph 3, his YouTube videos. Paragraph 4, generating ongoing, fresh litigation-related YouTube content. Paragraph 6, the basis of the federal lawsuit and accompanying YouTube storylines. And paragraph 7, litigation to generate YouTube content. Count 2. In paragraph 15, the plaintiff has misappropriated the defendant's image and likeness by placing them on video thumbnails in order to advertise the videos as bad neighbors videos in which the defendants appear involuntarily as villains in the plaintiff's contrived YouTube storylines. Have you heard about that?
Yeah,
It's,
I have.
so it's
So
like using the image of somebody
yeah,
in a
but there are certain exceptions. I mean, did the plaintiff take down those videos? I mean, sorry, did the defendant take down those videos? It doesn't seem so, right?
hold on. Which one? The plaintiff defendant. So okay, the plaintiff in this did videos and took like thumbnails and pictures, and it's not altering the pictures, but it's like they do. It's very typical on YouTube. It's like you have a shock face,
Yeah.
like
Mhm.
stuff like that, and then like sometimes like they'll put like tear balls or tear drops. I'm sorry, on their cheeks. It's like, oh, so sad.
Yeah, so
It's stuff like that.
the question is, were those videos taken down or are they still up?
I think they're still up.
Okay.
But anyway, in paragraph 15, the plaintiff has misappropriated the defendant's image and likeness by placing them on video thumbnails in order to advertise to neighbors. Okay. Count 3, in paragraph 19, the plaintiff has published the defendant's photo, image, and or likeness on his YouTube page and video thumbnails maybe occasion. So that's not being denied or anything.
Okay.
I mean, I don't even know. It's so like, I don't know. Yeah, I don't want to talk about it because that's a whole different rabbit hole. Let's just focus on what's on this paper here. Mr. Hales is entitled to judgment as a matter of law as to count 1, the intentional infliction of emotional distress. Oh yeah, he did put that in there. He is charging suing for that.
Wait, the defendant?
Hales is suing the defendants.
Okay.
Well, see, no, here defendant is defendant in this counterclaim, I think. No. Defendant is Cook in this one.
So
Cook and Preston is being sued by Hales.
So Cook is filing a counterclaim of intentional infliction of emotional distress against Hales in the counterclaim.
No, Hales is suing for intentional.
Okay, so this is kind of confusing because if he's trying to get a motion for summary judgment on the counterclaim, the fact that Mr. Hales has an intentional infliction of emotional distress case against the defendant, that's not a part of the counterclaim. That's a part of his own action.
Yeah.
So he's kind of mixing up his own action.
Well, he's asking for a summary judgment on everything here.
Well, it says a counterclaim, so I don't know.
It's, let's see.
Let's see.
Memorandum in support of summary judgment on the counterclaim. filed by
Yeah.
the defendant.
So it sounds like
So
he's bringing a summary judgment on everything, but it just says the counterclaim. So that's why I'm confused. But that's okay. We can keep going.
I see what you're saying. Now, that is a very good point. So if why they are again to be two separate things.
Right.
Now, let me ask you this: if they asked for a summary judgment before, because
If who
I
asked for
don't
a
remember
summary judgment before?
if Hales did, the
Uh-huh.
plaintiffs did, if they asked for a summary judgment and they haven't gotten a ruling on that, because remember this is something that's filed for something that hasn't happened yet, that's in the future.
Well, it is in the future, but yeah, it's so twisted. This is because they can't communicate because they don't communicate. The attorneys are not communicating. And it's because they should have, I still think they should have filed a separate action for a counterclaim and not put it within the answer. But let's say they can do that. Let's say they can put the counterclaim in the answer. Then they would have had a certain amount of time. The plaintiff would have had a certain amount of time to respond to the counterclaim, right?
Yeah.
But instead, that time passed. So now I understand they're bringing a motion for summary judgment on the counterclaim. The only issue that I see is that he's trying to get a summary judgment on his claims against the defendant, Hale's claims against the defendant for emotional distress. So it gets a little confusing.
It's very confusing. This whole
Yeah.
thing is, and I mean, this is. Hang on, real quick. Bad Duck says, "Have you ever tried to catch a fog?" He tried yesterday, but he missed. I love these jokes. I love them.
So,
Hey, Bad
yeah.
Duck, did you catch the worms in the fog though? Have you seen that? That's a thing now, evidently. The fog, it comes and makes you sick. Have you guys seen that? It's all over TikTok. There's worms in the fog. Don't ask.
Well, actually, Richard Thornton says, no, this is in response to the paper that had the red conditional in it. But it says up above, document 69, that it, in the title, it says motion for summary judgment on the counterclaim. Yeah. Memorandum in support of summary judgment on the counterclaim filed by defendant Cook, document 69. So that other document that we saw with a conditional red in it, that's not document 69.
No, that document was the memorandum in support of their counterclaim that they filed in their answer in document 69.
Yeah, it was the answer. Yeah.
Is that not bizarre?
This is just, it's really like mind-bending.
So this is the thing that gets me. Because everybody, there's a lot of people that read these things, they say, oh, they're stupid and they're just not. I think this is a strategy. And I think that you see the struggle like we're having right now, trying to keep this. I mean, how many cases are there that you can't just go sit down and talk to somebody about and be able to bring them up to speed real quickly? And this is one of those cases that you can't bring you up to speed real quickly. And there is.
Well, it's like you said, they're one step ahead of the judge where things need to be ruled upon.
The judge hasn't ruled yet.
Yeah.
Yeah.
And so in response to Richard Thornton, no, document 69 is not the red conditional. Document 69 is that answer. And it says answer, affirmative defenses, and counterclaim. Yeah.
So count two, the plaintiff has misappropriated the defendant's image and likeness by placing them on video thumbnails in order to blah, blah, videos in which the defendant appears involuntarily as villains. Three, let's see, or was it in paragraph 19, the plaintiff has published the defendant's photo, image, and likeness on his YouTube page. Oh, we just read that. Sorry.
That's okay.
I forget what it's doing. I'm so man, I'll tell you what, I am so warped right now. Trying to figure out when I started reading that again, I was like, whoa, wait a second, where am I?
So here we go.
Mr. Hales is entitled to a summary judgment. That's where this was.
Summary as intentional infliction of emotional. Okay, so
Distress, which is that's hard to prove too. And
yeah, defendant has not produced a single example from YouTube or anywhere else to support count one. This is because defendant cannot produce any such evidence as it simply doesn't exist. The count is based on YouTube videos, again, of which defendant has not produced or cited to a single example in the counterclaim. In this count, defendant alleges the plaintiff framed the defendants so he could accuse them of being responsible for the signs as a basis for filing his present lawsuit and creating litigation to generate YouTube content. The plaintiff's accusations that the defendant planted signs were and are false and known to be false by the plaintiff, and the plaintiff's statements accusing defendants of creating and planting the signs were made and continue to be made with malicious intent to injure the defendants. Okay, so
defendants here is Hales. On this document, it's Hales.
It's Hales.
Same case. Yeah, same case. He's the counterclaim defendant.
So when it says defendant has not produced a single example, he's talking about the counter plaintiff defendant.
Wait, hold on. Wait, am I wrong on this?
It's confusing as hell. Yeah, the plaintiff framed the defendants.
Yeah, it's accusing the defendants of creating and planting the signs were made and continue to be made in malicious intent to injure the defendants.
Yeah. So he's saying that this is what the defendant,
Hales,
which is the counter defendant. No, he's not the counter defendant.
I need to go get a drink. I gotta refill my drink. Is that okay?
Yeah.
I'm gonna put this right here. You can look at this if you want to. You don't have to say anything. Bad Duck will keep you entertained. He's
okay.
He's as bad of a duck as he is. He's a good person. So that makes any sense.
Okay.
So oh my God.
Yeah, this is mind-boggling. It's hard to read, especially this late in the day. I need to read something like this fresh in the morning. So simply by recite. Yeah. The counterclaim defendants are claiming that. That's what it sounds like to me. Single action rule. So now he's talking about a Florida single action rule. Count one of the counterclaim is simply the recasting of a defamation claim. Okay.
Now.
Okay, so what he's saying is that the defendant is trying to circumvent a valid defense to defamation. In other words, they don't have a defense to defamation, so they're trying to circumvent it by recasting the same facts into several causes of action that are all meant to compensate for the same harm. Okay.
Oh, he's awesome. Okay, so
what he's saying, so he's just saying that they're trying to avoid they're trying to avoid an affirmative defense because they don't have one, and instead they're trying to counterclaim against the plaintiff counter defendant.
Yeah. Okay, so all right. Yeah. Yeah, that makes sense. Of course. Yeah, that's exactly what they're doing. They don't have a defense, so they're just going to say, "Nah, you do it."
Well,
Yeah.
that's what this document is saying. Whether they have a defense or not, I don't know, but that's what this document is saying, that they don't
Yeah.
have a defense. So what they're doing is they're trying to formulate a counterclaim that is essentially defamation, but they're not phrasing it that way, and it violates this Florida rule that precludes the recasting of a defamation claims as additional distinct causes of action in tort if all the claims arise from the same defamatory publication.
Let me go back here. Hold on. Is this where's the defendant? Where a defendant, or whereas here counter defendant, moves for summary judgment on issue in which, yeah, okay, so right, so that's the counter defendants who he's talking about here.
Yes.
Is okay. We find no expression or claim instead.
Counter defendant is the plaintiff.
Okay, wait a second. Was that last one? You know what? It was the motion for summary judgment is the one that called the defendant. So maybe that's where I'm confused here. Maybe the defendant's still the defendant here, the original defendant. I keep getting lost.
Yes, I think you're right. I think the defendant is the original defendant. They didn't
the cook.
Yeah, they didn't. Defendant has not produced a single example. Yeah, so that should be defendant, or it should be actually counter plaintiff / defendant has not produced a single example.
Yeah,
that's it.
Okay, so that makes. I think that's where I was getting confused, but that was on the other document we read. It was the motion for summary judgment. This is the
memorandum
of law. Okay, see here.
So we were here on Florida
rule. Count one of the counterclaim is simply the recasting of a defamation claim as additional distinct cause of action in tort. This is not allowed in Florida in accordance with the single publication, single action rule. The rule is designed to prevent plaintiffs from circumventing a valid defense to defamation by recasting essentially the same facts into several causes of action, all meant to compensate for the same harm. So what's that? Is like if somebody reprints something?
Well, now that I'm reading it, the rule is designed to prevent plaintiffs from circumventing a valid defense to defamation. But why would the plaintiff have a defense to defamation if it would be the plaintiff that's suing for defamation? I guess they're trying to do it by analogy. In other words, the plaintiff can't circumvent. Okay, the plaintiff can't circumvent a valid defense to defamation by recasting essentially the same facts and several causes of action, all meant to compensate for the same harm. So, yeah, so if the plaintiff can't do it, then neither can the cross plaintiff / defendant, because the cross plaintiff, who is really the defendant, right? The defendant filed a counterclaim, right? So the defendant then becomes the cross plaintiff. So that's right.
See, I take it as being more if you have a defense for defamation, say just like newspaper, a magazine, and a TV station, and the TV station has a good defense, and so then you go after the magazine and the newspaper for printing the same thing, but they don't have a defense. They don't use the same defense as the TV station or whatever. I don't know. I was going somewhere. It was brilliant here for a moment, and then it just fizzled out. It just went away. Sorry, don't pay attention to me.
Well, essentially, plaintiffs could because this is against the counter plaintiff. Plaintiffs in this document here that we're reading is the counter plaintiff, because that's who he's talking about. So if you just look at the cross complaint from the defendant as just a plaintiff, let's pretend he's just a plaintiff filing a claim against the plaintiff cross defendant. If he's just a plaintiff, the same rule would apply. It's what I read it as pretend the cross complaint is a separate action. It has nothing to do, there's no cross in front of it. So pretend that the defendant is a plaintiff, period, and is suing Hales. They can't, they're precluded from circumventing a valid defense to defamation by recasting essentially the same facts into several causes of action. So the same facts into different causes of action when the compensation is just one, like emotional distress.
Yes. So it's like, so the defendant here, like, no, so what it says, in as much as the defendant, this is
cross complainant
we're talking about.
Yeah.
Yes. Okay. Yes. It has produced no evidence at all, not even a single example with the entire counterclaim. The conclusion that there is no such publication that fits the elements of intentional infliction of emotional distress. And that's, I mean, I haven't seen that anywhere brought up.
Oh, it's, assuming that the defendant, counter plaintiff, is a public figure, and I don't know if they are or not. Well, in any event, it doesn't sound like there's any elements of emotional distress in their counterclaim.
No. Let's see here. In order to state a cause of action for intentional infliction of emotional distress, the plaintiff must demonstrate that the defendant acted recklessly or intentionally, the defendant's conduct was extremely outrageous, the defendant's conduct caused the plaintiff's emotional distress, and for the plaintiff's emotional distress was severe.
And based on the
defendant cannot produce any evidence that the YouTube videos were not protected speech. Now, see, this is where it's starting to sound normal to me. So it's saying that, this is why you did this. Why they're asking for the summary judgment. Hang on a second. Let's see what we got. Patrick W over here says the single action claim statement is what the hell saying that Lynette trying to move the thumbnail case from the state case to this federal case using a counterclaim. Okay. Oh, I got you there. So that's the thumbnail. Like there was a state action. They filed in state court. I think they're supposed to have had a hearing like on February 5th or something. I forget what happened. But anyway, yeah, I don't know what's going on with the state case. And I think they withdrew it maybe.
I'm laughing at Bad Duck's comment, not you. I'm not laughing.
Anyway, they're trying to get the thumbnail case as part of their counterclaim. Now that makes sense, Patrick. I see what you're saying. That's still. And Bad Duck says hummingbirds are just regular birds that don't know the words. It's like, you know what, Bad Duck, when White Rabbit was talking about doing like humming Christmas songs around the crowds trying to, earlier, I was like, I didn't hear that. And it's like she started humming all of a sudden. I was like, when did you become a hummer? That's so weird. I'm like, why are you humming? I feel like I'm with the church lady. Sorry.
Okay.
I forgot the word.
So yeah, this is such a roundabout way to do this. I don't know. It's very confusing, but I think I understand it.
So we got the
It's basically he
plans of
has a
emotional
First
distress.
Amendment right to say these things, and the counterclaim doesn't allege emotional infliction of emotional distress. It just alleges that it's YouTube content, that they did this.
Yeah.
They basically they published photos of this person. They took his likeness or her likeness and put photos on a thumbnail. On the
So
thumbnail.
the First Amendment protects uncomfortable speech. Like you can say things that people may not like, uh, but you can't say things that is specific to do damage to somebody. So, um,
But
and that's where
yeah, and the
because
first
I'm just saying that you have two things you have to overcome here. One, you have to overcome that is protected free speech, and then two, you have to prove that it satisfies the elements of intentional infliction of emotional distress.
yes,
So it's
and
a two-tiered system. And
mhm.
what the Randy Shockett here, the attorney for Hales, is saying is that they right here is defendant cannot produce any evidence that YouTube videos were not protected speech, which Hales has under the First Amendment rights.
Yeah,
Not to mention that in order to state a cause of action, you have to meet these four elements. And there's no such publication that fits the elements of intentional infliction of emotional distress. So that's why they're asking for summary judgment on that. On something that hasn't even been granted.
yeah. See, it's a little
On a
premature.
counterclaim that's not even granted.
Well, it's in the document. So here's the thing. If did she answer the third day?
Was that you? Were you supposed to answer that, or was White Rabbit?
Did she answer the third date?
I think Bad Duck's asking you out, maybe.
Oh, sorry, bad duck. I don't date ducks.
Oh, but he's housebroken, he says. I doubt it, but
No.
what's a duck's house look like anyway? It's just a big nest.
Okay. So I get it. It's just a weird case, but because the counterclaim is in the answer, and technically, I guess the judge has to say there's a valid counterclaim because there was no response to it other than that conditional request or whatever it was to dismiss it if the case gets dismissed.
Like right now, this there may not even be standing for summary judgment.
Well, yeah, because there may not be because the judge hasn't said that the counterclaim is valid, but
It's
I don't
viable.
know.
Yeah.
Yeah, but I don't know how he would do that if the counter defendant plaintiff didn't respond to it. And that's why I said that it's better to have a separate counterclaim and an answer so that the counterclaim, it gives you a time to respond just like a complaint would. So, you file a complaint against somebody in federal court, you have so many days to respond. So when you file an answer, that doesn't give you so many days to respond. But if you file a separate counterclaim, counter complaint, then you have a certain amount of days to respond. So technically, the judge does have to allow the counterclaim, I guess. I don't know. It's very confusing.
Yeah, it's crazy. And it's like Funds was saying she ran for office, making her a public figure. Well, so like there's two things. Like one, that I would have a question like, so if she's a public figure though, how does defamation work if it's outside the realm of that office? Which I mean, I'm sure there's an easy answer for that. I just can't think of that right now. But also though, but the main thing is like, okay, so like when you have like she ran for public office, it makes her a public figure, but that's not being brought up for purposes of this right here, the document in front of us.
Correct.
Everything that's my thing is like everything in this whole ordeal is about the document in front of you. And I think that's where people get they bring in all this lateral information that doesn't apply to the case at hand. You don't have outside sources.
Yeah,
Yeah,
because she's
it's
not yeah, they're not arguing that she's a public figure, so therefore this is okay. They're arguing that the allegations in the counterclaim don't rise to the level of a case, and they don't allege emotional distress, and the Florida single something rule.
single issue rule. That
Single
being
issue
said, have
rule.
you noticed the rungs on ladders getting further apart through the years? Definitely climate change.
Mm. I have noticed that the weather's getting crazier.
It's climb it.
Haven't you noticed the weather's getting crazier?
Yeah,
Or
it's
no?
February.
Yeah. I mean, I don't know if it's
They have
climate.
a weather machine in Alaska that does all this. It's true. That's what I don't know. Somebody told me that on a bus, and I don't ride buses, so go figure. Bad duck. Eagles may soar, but weasels don't get sucked into jet engines.
That's true.
That is facts right there. Facts. All right, let's see here. Sorry. The freedom of speech one's mind is not only an aspect of individual liberty and thus good unto itself, but is also essential to the common quest for truth and the vitality of society as a whole. Hustler magazine. That's Larry Flint, isn't it? The
Yep.
People versus Larry Flint.
Obscene and outrageous.
Do what?
It stood for obscene and outrageous. And I believe one of the justices said that I know obscenity when I see it.
Yeah, is that from the that case?
I think it is. I'm not.
I know pornography when I see it, but I
Something
can't
like
describe
that.
it to you.
Yeah.
Let's see here. And the Supreme Court rejected the notion of the concept of outrageousness, which is an element of the tort of intentional infliction of emotional distress, would provide sufficient protection on the First Amendment rights of a defendant. Outrageousness is the area of political and social discourse, has an inherent. Oh, by the way, I just want to point out, do you see how this is formatted right here, everybody? This is the way it's supposed to be when you cite something.
Now, when you're quoting directly.
Yeah, quote something big. It's not supposed to be just indented on one side and then it goes all the way out to on the other side. It's supposed to be justified and goes in. I forget how many. Was it 2 tabs or 10 spaces? Forget. Sorry. Anyway.
Yeah, if it goes beyond like a mere sentence or two, it has to be like in.
Yeah, it's like if it's gonna be 3 sentences, it has to be like this, I think.
Yeah,
something
like that.
An outrageousness standard thus runs afoul of our longstanding refusal to allow damages to be awarded because the speech in question may have an adverse emotional impact on the audience. Speech does not lose its protected character simply because it may embarrass others or coerce them into action. The fact that society may find speech offensive is not a sufficient reason for suppressing it. Indeed, if it is the speaker's opinion that gives offense, the consequence is reason for according it constitutional protection, for it is a central tenet of the First Amendment that the government must remain neutral in the marketplace of ideas. I love that sentence, marketplace of ideas. The public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of their hearers. So that's all from Supreme Court. It's here Snyder v. Phelps. The Supreme Court extended the First Amendment protection even beyond actions for intentional infliction of emotional distress instead of stress. I don't know. To include claims for the violation of plaintiff's privacy rights and for civil conspiracy. Moreover, the Snyder Court held on Hustler that free speech clause of the First Amendment, Congress shall make no law abridging the freedom of speech, can serve as a defense in a state tort suits, including suits for intentional infliction of emotional distress. Defendant can produce no evidence that hasn't even included any such evidence in the counterclaim itself, where the First Amendment does not defeat the claim for intentional infliction of emotional distress. This means that this claim fails as a matter of law. Question: where does the First Amendment, when do you defeat the First Amendment on a claim for intentional emotional distress?
When you have facts that you plead in a complaint that says so and so did this, they did it with malicious intent, they caused me extreme severe emotional distress, uh, and the reason why it caused them emotional distress because it involved my child and involved private matters that are embarrassing to me, that were not privy to the public, something like that.
I think we even spoke before. It's the key to it is malicious,
Yeah.
and that's always the key.
Even if he was doing it for YouTube content, let's say Hales was doing it for YouTube content, that doesn't necessarily mean that it's malicious.
Yeah,
You know, it could be, if he's trying to ridicule them, but it doesn't necessarily mean it's malicious. Malicious is, you got to show a little bit more. I think.
yeah, right.
I think so. But I don't know. I'm not totally up to date with the law on this, but that's what I remember. You have to plead emotional distress. You have to plead intentional infliction of emotional distress, meaning that it was intentional, not that it was negligent, meaning they said something
Yeah.
and negligently or haphazardly and it caused them emotional distress. It's intentional. So the intent there is to do content, not to cause them. They would have done better with negligent infliction of emotional distress, but no.
I mean, I don't know. I have nothing to add. Sometimes I have to remember just to shut up.
Well, I mean, that's my thought, and like I said,
No,
I
you're
don't
right.
want
I
to
agree with you.
with this, but
Let's see here. What's the Hales is entitled to judgment in a matter of laws to the count 3 invasion of privacy by unauthorized publication. Defendant has not produced a single example from YouTube or anywhere else to support count 3 to show invasion of privacy based on publication of private facts. A plaintiff must prove 4 elements. The disclosure was public, private facts were disclosed, the matter publicized was highly offensive to a reasonable person, and 4, the matter is not a legitimate concern to the public. Defendant complains about publishing defendant's photo, image, and/or likeness on plaintiff's YouTube page and in video thumbnails on many occasions. If this were the case, then it is difficult to explain why the defendant has not produced a single example of this publication. This is because the defendant cannot produce any evidence that would show the defendant's photo, image, and/or likeness on plaintiff's YouTube page and in video thumbnails were not already publicized elsewhere and republicized.
right.
Now that's interesting.
Yeah. In other words, if you're going after him for publishing your photo, why aren't you going after these other people?
That's where that Florida law comes into effect. You can't go after other people trying. If somebody has a defense, you can't go against other people to try to get a judgment.
Yeah,
I think that's.
I
I
think
think that's my understanding.
I think so. Yeah, I think yes. I'm trying to think. Yes, I think so.
Yeah, no, she really brings up a good point. So one of the things that Jeremy always said was, he's making everything about himself, this whole ordeal, very public, to protect himself. And so it's like everybody, he kind of always put people on notice that you will always be filmed if you're around me.
Yeah, and yeah,
And it's weird. So like I think that part of this case I just figured it out. I just figured it out in my head. That will make sense. I can't share it with anybody. All right, sorry. Um, that was great, wasn't it? I just had a light bulb moment. I think that I can't share with anybody because I got to figure it out first.
You got to figure out how to
Um,
articulate it, how to say it.
yeah,
Okay.
yeah. Um, let's see here. A photograph taken in a public place is not private. Heath v. Playboy Enterprises. Defendant cannot produce any evidence that would show the defendant's photo, image, and or likeness, YouTube page, and in video thumbnails was not taken in a public place. Facts taken from public record and proceedings are not private. A defendant cannot produce any evidence that would show the defendant's photo, image, and or likeness, YouTube page, and video thumbnails were not taken from public records or proceedings. Even otherwise, private facts may become public when acquired by legitimate means. Defendant cannot produce any evidence that would show that the defendant's photo, image, and or likeness on plaintiff's YouTube page and in the video thumbnails were not acquired by legitimate means.
Yeah, because they have the burden. If they're filing a counterclaim against the plaintiff, then the counterclaimant has the burden. So, yeah, that's correct.
Hey, Yolie, do you want to hear two short jokes on a long joke? Joke.
Maybe that's where I got Bad Baker. It was from Bad Duck.
I love them. I love them. They get me tickled every time.
I kept calling him Bad Baker.
There's a Natalie Baker here, and she had her name as Nat, Nat for Natalie. And I read it as Not Baker, and I just thought it was somebody came over from his channel. I'm Not Baker. They're calling her Not Baker, and so she changed her name to Not Baker. Hey, Daz, how you doing? Oh, Tony from Oz. I hope I've said hi to you. I've seen you in this chat. I can't remember anything. And then also, Josh, I think I hope I've said hi to you too, because you got a lot of good info here you've been sharing with us. Side zero case law, or just basically whining that we aren't doing it. You are.
It kind of like a you projection, like, no, it's not us, it's you.
Yeah, everything's a projection here. Consent is never even reached where no disclosure of private facts can be demonstrated. This means the consent is not an issue in this case. Finally, the right to privacy does not forbid the publication of information that is of public benefit or general interest, and the right does not exist as to persons and events in which the public has a rightful interest. That was a 1947 case in Florida and a 61 case. Defendant can produce no evidence and hasn't even included any such evidence in the counterclaim itself. Where the above does not apply, this means the claim fails as a matter of law. How do you like that language? Yeah,
No,
I always judge the way like they others write, and so like this, like when you say this matter that this means that this claim fails as a matter of law. I love those words.
Yeah, and it's a matter of law because, like they say, there's no genuine issue of material fact. So they're basically responding to this as they would a complaint, like a motion to dismiss a complaint. But they're doing it in a summary judgment motion, which is allowable. As far as I can remember in federal court, yeah, it's allowable. And they can use the pleadings as a matter of law to say that they don't meet the burden of carrying this counterclaim against the counter defendants. So the claim fails as a matter of law.
Hales is entitled to judgment as a matter of law to count 2, those Florida statutes. Defendant has not produced a single example from YouTube or anywhere else to support count 2, section 540.08 of the Florida statute prohibits the unauthorized use of a person's name or likeness for trade, commercial, and advertising purposes. So that is this is goes back to that thumbnails case where they filed suit in state court saying that you were using my likeness to make money off of it, and there's a law in Florida that you can't do that, which I think is that's kind of it's a strange law. I mean, I get it, like if you're intentionally making money off of it, but I don't know. There's a lot of questions I had to it. It doesn't matter, right? It has nothing to do with this. Let's see here. Section 540 prohibits using a person's name or likeness to directly promote a product or service. 540.08 prevents the unauthorized use of a name or personality to directly promote the product or service of the publisher. NFL v. Alley, Southern District of Florida, Section 548. Florida statutes prohibit unconsented use of an individual's name and likeness only when such directly promotes a commercial product or service. I think that's the key thing. What?
Yeah, that's interesting. I think that's right. Yeah, it's coming back to me.
I mean, yeah, you can't say that. You can't have, Mickey Mouse was standing in line at McDonald's, and then you take a picture of it and say Mickey Mouse eats at McDonald's.
Mouse likes McDonald's, yeah.
Yeah. That was the key thing. I was like, what bothered me about the statute and the case, the suit was like it was like a general person. It's like you're not trying to sell a specific thing. You're not trying to say like, hey, expert supports Tide Pods because he said they tasted like Fruit Loops. So hold on, wait a second here. T for 2 with 10 memberships. Thank you so much, T for 2. And I'm pretty sure they're updating it, or probably not. I need to update the membership link. Thank you, T for 2. Sometimes she doesn't. I think she does. I know one, she likes having the Discord full. I know she loves that. And also I think she does it because it kind of puts me on notice that I haven't done what I'm supposed to do. Love you, T. Defendants can produce no evidence that and hasn't even included any such evidence as counterclaim itself, and the above does not apply. This means that the claim fails as a matter of law. Conclusion: because there is no evidence to prove a fact necessary to defendants' counterclaims, Mr. Hales is entitled to summary judgment as a matter of law.
Aren't they supposed to sign that though? Well, maybe not, because
electronic
motion. Oh, there it is. Yeah.
Or,
oh no, that's a service list.
Yeah.
Maybe it's because they signed the actual motion, the notice of motion. I don't know. Everything.
That's the last thing I'm worried about right now.
Yeah. Well, so, I think they signed that original document, the first one that had the notice of motion. Boy, that was a mind-boggling. I'm actually.
Isn't it though?
I have like 2 brain cells right now trying to keep up. It's with the counterclaim and the claim and the counterclaim. And then it's not clear, like, because we're not looking at the counterclaim itself. We did look at it, and I know what document they're talking about, but in terms of what they're asking for. But anyway.
Bad Duck says, what did the pineapple say to the banana? Nothing. Pineapples can't talk. I'm not going to say my only joke. Sorry, it involves a banana. So it's the only joke I remember.
Yeah, the notice was signed, I think. The motion for summary judgment.
Yeah, Rich Thornton. Yolie, you did great.
It was I'm like exhausted.
It's crazy, right?
It's because it's late you did.
Wiggle, 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 wiggle. Wiggle, 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 wiggle.
Hey, I'm here to please. I'm here to please. So when I went to go get a Coke, I was like, this is just further proof. I have to have a printer. I don't know how you do it, but I got to have that physical paper. Like it's like I got to be able to see it and touch it. It's different. I can make notes on the side different. Um, a computer or anything like this doesn't do it for me. When I'm going back and forth on stuff, I like to have the paper. I like to have that file.
Yeah, me too. I'm that way too, but I'm getting used to it being on a computer. Because paper, I don't have to buy paper, but but yeah, the paper is always good to have. I mean, it's cumbersome to go to court or go anywhere and you have to have your laptop in order to look at a document. I mean, if you have a paper, it's better.
Yeah. I mean,
Oh, thank you, T42 or
yeah,
T42.
it's actually T42, and then I called her T42 in chat. And see, everybody gets nicknames around here, Yodels.
Yeah. I like that nickname though. Well,
hey,
Baker
that's it.
still
Yodels.
Baker still calls me Yolie.
He does it the Danish way.
Yeah. Actually, my name is often spelled or can be spelled as Eulanda. Yolanda.
I couldn't even follow the letters you were using.
Eulanda.
Oh, let's have a Y.
Or Yolanda.
I like the letter Y. It's underused. Yeah.
Well,
Like there's certain letters I just dig, like I'm sorry, I know it's weird. There's a tech company called Akara, and it's AQARA. And I think it's really cool because they don't have a U after the Q.
Mm-hmm.
So stupid. I mean, this stuff I'm like, oh, that's really neat. I really like that.
Yeah.
Isn't that weird? They sell doorbells.
Yeah, I kind of didn't like well, I mean, not didn't like, but when people would call me Yolanda, and it's like, well, it's not Yolanda, it's Yolanda. I know it sounds weird, but phonetically it's Yolanda. But never mind,
Over
it's
here it's
Yolie.
Yodels.
Yodels. Yeah.
Let's see here. Don said, I think Tug said there were 80 some odd things filed. Tell me where to download all those papers. Yeah. I mean, it's just it's ridiculous. It's going to get crazier and crazier, and it's going to get to the point where you have to skip stuff. And
Well, you know what might be good? It might be good to see when the judge puts out something in response to something. Because then you just cut to the chase. Because the judge not all judges do, but they have to explain their reasoning for why they're deciding a certain way. So maybe it might be better doing it that way instead of trying to figure out what these people are claiming.
Yeah, just follow the judge's stuff, right?
Because let me see.
Zach's got
Oh
you.
my God.
There you go.
Oh, answer.
What's happening?
Affirmative. Okay. No, he sent me some documents. Okay. Shane did. Shane Reynolds.
Yeah, Shane's awesome.
Yoda lady who. Or you could just call me Yo too. Okay.
Yeah, but I say yo to people all the time.
It's like the laziest. It's like,
hey, yo.
Yolanda. There's like 3 syllables. So Yolie is 2 and Yo is 1. So
you're a good sport about it. You're by the way, thank you so much. You're a good sport about this. Holy cow, man. That's this is an ongoing thing.
it's silly. They should just work it out.
They should. And here's the thing. It's not I don't know. There's so many different levels of it. If you saw the stuff that happened in state court, your heart would break for uh the Hales, because it was like, this is not how you're supposed to do any of this stuff. Like, it's the court's supposed to be fair, right? You're supposed to have the scales of justice and all that, and it didn't. I mean, you didn't have it. Um, you go to federal court looking for a remedy that you should have a federal court's more adult court, right? I mean, it's not like a small claims in Florida in
Mm.
was it Levy County, Florida. Um, and then you get there and you're being just tortured with all these motions and claims and everything. And here's the thing is that all this stuff costs money. And the attorney is doing it for them, is doing it for free. And, it's how he has that type of time, how he has that type of resources to be able to do that is
Yeah.
something else too.
And federal court is hard to practice in because, the judges, there really isn't a time limit. I remember practicing in federal court in certain civil rights cases, and the order, like, they would be it'd be months before they would rule on a summary judgment motion. Like, there's no time limit or there's no urgency. It's whenever they get to it. And they're appointed for life, federal judges, so they can't really be fired. So
And be impeached, but how many
yeah,
times does
but
that happen?
no, they just, and I remember there was a federal judge, I'm not going to get into that, but he was very nasty to the women. And he just
Oh
got away
yeah,
with it. He just got away with it.
yeah. That's just old Judge Purvey up there. I mean, I know exactly what you're talking about. There's hang on real quick. Bad Ducks wants to know, Yodels, what do you call a moose with no name?
Nani Moose. That's cute. An anonymous.
There was a judge locally here. He presided over a horrendous murder trial.
Oriendes, Oriendes, Oriendes. Why does that sound familiar? You said Oriendes?
Horrendous.
Oh, horrendous. Sorry.
Yeah, sorry. That's my Tennessee going out. It was an awful trial. It was the facts are just devastating. And you want to talk about true crime? That's one. There's a lot, man. I'll tell you what, the woman that covered this stuff, she's a good chick. Like, you could call her up and she'd do an interview. And I thought about doing it too, but I started looking back into the case and everything. It's sickening. I don't think I've got the fortitude to do it. It's a awful crime thing. But anyway, the judge that presided over the case, after the case was over, after there's conviction and all this stuff, turned out that the judge had gotten with some chick that was in his courtroom for drugs. And next thing you know, he's taking some drugs that she's bringing him, some kind of pills and stuff. Anyway, they were saying that he was abusing pills and stuff when he was on the bench during the trial. And a judge came in, a retired judge. After you retire in Tennessee, you can still be a judge. You can travel around and fill in where you need to and stuff.
Mhm.
Well, anyway, he came in for the judge that was dismissed for being a drug addict. And he said that the defendants get new trials. And you talk about, man, it rocked the area. I mean, it was so horrible. The family had to go through it again and everything. It's just, but anyway, yeah. But that judge, though, it's like, I think about him, and you say, like, there's horrible judges sitting there and they can do what they want. A lot of judges, there's not many people question, It's
Yep.
just my fake attorney, the tilted lawyer, handles all my paperwork.
I've heard of that, tilted lawyer.
Felt like the tilted skirt in that bar.
All these names are now
Tilted kilt. The tilted kilt. That's what it
I'm
is.
starting to recognize all these names that aren't even being said, like horrendous.
Yeah, it's
You said horrendous.
yeah, horrendous. Sorry. Take that out of your ears. Oh, sorry, I said it.
Because there was
Horrendous
a
is
case
a
for horrendous that was a bad case.
do you have to pay federal court fees per filing?
Yes. Well,
Per
if you're
each motion?
if
You don't
you're
have to.
initiating the motion, I think.
Do what?
If you're initiating the motion, I think you have to file.
Well, I know if you on the complaint you have to pay
Yes,
for it,
you have
but
to pay
you don't
for it.
have to for answers and stuff, do you?
I think for the first appearance, if you're answering and it's your first appearance, you have to pay a first appearance fee. Well, at least I know in California you do. I mean, I forget federal court. I haven't practiced in federal court in a long time.
Yeah, I don't. It seems like it's just special interests is all that goes in federal court anymore.
I don't know. It
You
just
know,
seems that suing people is just a waste. Sometimes the way things go, it's just. And California is like totally backed up on all kinds of things. I mean, you file a motion and it gets set after the current trial date. So then you have to file an ex parte to get shortened time for the motion to be set at least 3 months before the trial date. It's just like, how can that be? It's getting harder and harder to practice, but oh well. I'm sticking it out.
Yeah. When I was in school, this is a Tennessee statistic they said was what was it? It was less than 3% of the state budget is on judiciary. It's like, so you think about there's three branches of the government, right? You got, I mean, that's not a fair thing to say because the executive branch is in charge of everything the legislature passes. But it's just talking about like, the judiciary is so low compared to everything else. And then so you think about is that why everything gets backed up in courts and everything else? Because there's not enough judges and there's not enough that's why mediation's becoming a thing and arbitration and all this stuff. I don't know.
But
It's not fun.
arbitration is kind of expensive because you have to pay the arbitrator. Unless so in Kaiser arbitrations, because they do arbitrations, you can get a waiver to waive your fee if you're, indigent. But there was another thing I was going to say. Oh, COVID really did a number on the California courts. Some counties have almost recovered, other counties still. They're like Riverside County is so bad that they're so backed up. There's not enough resources, and because what they did, they had to dismiss a lot of criminal cases because there were no courtrooms and they didn't waive their right to a speedy trial, and there was no courtroom, so they had to dismiss them, and it's terrible. And civil cases were backlogged because the criminal cases had to go first, and there wasn't enough courtrooms. And I tell you, it's crazy.
Well, that's what I was going to ask. Like, how did civil? Because criminals got to take precedence. I think it's I just like I don't know. I mean, I don't even know how you do civil and keep. It's like what they need to do. They need to have like They need to have 3 courts to be open 24 hours a day. 3 8-hour courts.
The night owls can do the night trials. No, it's just it's a mess. And it's bad when even the judges say, you know what, I'm gonna have to continue this hearing because there was a lot of cases in front of you. I wasn't able to get to this, so we're gonna continue it. And it's just, oh my God.
Lisa Kay now. Jeremy, are you allowed to film?
No.
No, you can't have cell phone.
Federal, no.
No, they lay smack down on you real quick.
You can draw pictures. You can get an artist.
Yeah. Yeah. How do you feel about that? Some people are against the ban on cameras.
Oh no, I think they should be allowed.
You do?
Mhm.
See, I don't know. Like there's part of me that's for and part of me is against it. It's just it's a weird.
Well,
Some trials become such spectacles. I mean, what's like Karen Reed's one right now. You know, who was the one that lasted so long, like a year ago?
Murdoch,
Gosh, I got move. I got. Did you see
Murdoch,
that? I'm yawning. I'm not catching my breath right here. Do I now? Murder. Oh, that's a huge. Well, that was the court clerk though. Ended up being the spectacle there, right? Didn't she want to write a book?
yeah, the court clerk, yeah.
Holy cow! Lefty, 17 months of membership. Who else is on the on team?
Oh,
Lefty, you stirred the pot, man.
so Richard Thornton is asking, wouldn't violent criminals fall under the force majeure because of the fires, meaning delaying court cases? I'm I don't know how the fires have affected the courts yet. I'm sure I'll find out. I mean, the courthouses didn't burn down, but there's just bad air quality, and for a while the court staff wasn't there, or it was very skeletal in LA, meaning. And then people's houses burned down. So defense counsel, one a case that I have, her house burned down. So I can't be too hard on her for not calling me back. You know what I mean? I have to kind of wait, until she gets,
I mean, how do you? Yeah, I don't even know. Covering those fires has made me rethink so much about my own life. Like, I don't have I have to have this with me thing. Like, I would burn up in my house trying to get everything.
Well, no, it's true. I had to be evacuated from my house like 7 years ago because there was a fire in the canyon here. So,
Um,
so I had a feeling that my house wasn't going to get burnt, but I didn't have everything. I only had enough time to get pajamas, a couple of toothbrushes, brush. I don't know what else. That's it. Because it happened so fast, and they came and they said, "You got to get out!" I'm like, oh my god! But we had a lot of ashes in our house. Ashes, just. I swear, I feel like I have black lung disease. Like my lungs are just. When I go out, I put on like cover.
it's when watching those fires, one of the things you're like you didn't have time to grab stuff. Like somebody said, yeah, maybe it was a fire chief there or something that said, if you do you need your charger for your cell phone? Yes. But if you're under this condition,
No.
if you're under this condition, no, leave the charger. Just get out of there.
Yeah.
And I was like, holy cow, like that's something that got me because I was like,
Well, remember
yeah,
the cars that were that they just left their cars there and took off running. I mean, that
is
was
that not
crazy.
crazy? And then half of them burned up. That's the
Yeah,
thing, was
and
weird.
then they had to move them. Oh my god.
Yeah, with a bulldozer.
That's when I was
God,
watching you. That's when I first started watching you. I had already seen the Friday show, and then I started watching you for that.
yeah, that was
Oh,
crazy.
yeah. Sorry, Richard Thornton, you're a Katrina survivor. Wow.
Oh wow.
Yeah, those kinds of, but luckily everything burned over here already. So, the Riverside fires are the ones that are closer to me than the ones in Pacific Palisades. But
Yeah, oh yeah, that's right. Because that was another. Yeah, it's just. Yeah, are there any fires going on right now? Are y'all out of
no,
that?
yeah, no, there's no fires, just the aftermath. And toxic fumes over there. Like there's all kinds of. But the crazy thing is, if the courts were to burn down, that would be crazy. So yeah, San Diego County and Riverside County are the ones that are a bit closer to me than Pacific Palisades. But yeah, imagine if the courts burned down. And people, there were videos of people starting fires purposely.
Yeah. Yeah, I know. And then they want to ignore that, you know. It's like the one I saw was they got the guy, he had a blowtorch and he's on a bicycle and he's homeless. He's like, and they released him. I'm sitting there like, who's, I mean, okay, let me just say this. Like, maybe we just might need to hold him for a little bit longer because I'm just thinking, who carries around a blowtorch through a fire? I mean, it was through a wildfire, right? It was so weird.
Yeah,
Weird.
and they let them go, but I guess, but there was these two kids that were videotaping on YouTube. Not even a really, I mean, they had like maybe 10 subscribers, and I happened to run across them, and they were filming people. Look at this, and they were going, and people would start fires, and they would go and pour water on the fires, and they were filming it. They were called the Dew Brothers, I think.
Oh my gosh.
DEW Brothers. And something
Big
like
Mountain
that.
Dew.
But yeah, they were showing it, and they had buckets of water ready to put out the fires. They wouldn't engage with the people that were starting the fire. Like, they wouldn't go and tackle them or anything, but they would just wait till they leave, and then they would go and throw water on it. It's crazy.
It's so weird.
I don't understand.
Yeah, it's a weird world. You know, it's
Yeah, I have
actually weird.
allergies, so the air really affects me.
That's how. Let's see. Hang on a second. That's how I am. Like air quality. Like, I just learned how bad it affects me recently, and it's horrible. It sucks. And we, like, Tennessee, we've got horrible air. It's horrible. But anyway, no, it's I couldn't imagine being in fire and all that. Well, actually, I take back, there was a few years ago, there's a bunch of fires around here. I forget what was starting them. And you heard the stupid rumors were like, oh, it was real big about people were getting they were gathering these huge stones, rocks, things like for building fireplaces and stuff. They were selling them. I don't know. It doesn't make sense when you say it out loud. It doesn't make sense, but I mean, there are all these brush fires everywhere in the mountains. And you could see it, like, I mean, you could see the mountains glow. It wasn't catching fire like a big fire. It was just
A slow
I don't
burn.
know. Yeah, just a slow burn, and the air was it was smoky. You know, it was like you walked into a fireplace. You know, there was no fire, but you could smell the fire and everything. It was it was weird.
Yeah, that
But
when I had to evacuate, when I came back to my house and I started getting runny nose and stuff, I would blow my nose and black stuff would come out.
oh
It was ash.
yeah, yeah,
It was just really nasty.
yeah, it is. Yeah. Let's see here. Yeah, thank you, T. Yeah, don't forget to subscribe to Yolie, y'all. Is there anything else going on tonight? Anything you can't think of anything with this case?
Oh,
It's just
I need to like relax because there's too, I can't
right.
like anymore. It's because of I don't know the case, right? And
Mhm.
with the cross defendant, cross plaintiffs, and not knowing. Oh, Melody Couture is in Temecula. Oh,
Yeah.
I know where that is.
Yeah, Melody's
Interesting.
awesome.
Yeah.
Yeah, Melody hangs out back there in Discord. All right. Well, hey, we're gonna end this, all right?
Okay. Well,
Nice.
it was. Oh, I'm in Orange County, Melody Couture. Yeah, I'm by Peters Canyon. I'm like right down the street from Peters Canyon where there's all this hiking, and so I'm in the hills of Orange. Kind of like where Tustin, Orange, and Irvine meet.
Were there a lot of oranges there? Why it's named Orange County?
Yeah, there was a lot of orange
Really?
groves. Mhm.
Oh wow. Wait, I just kind of took a shot there. I was like,
Yeah, there were orange groves, all like A lot of Orange County was orange groves. Yeah, that's why they called it. But there's hardly any orange groves anymore.
Yeah, that's what it was like. Bad Duck is just was, man, it sucks. It's so weird to try to explain unless you know. Of course, I mean, I always sound like an idiot when I'm talking. So I'm going to end this. Thank you all so much. Yodels, thank you so much. And we'll talk. We'll try to figure out when one of these